is any policy changes subsequent to the incident at question here. We are in agreement that those policies, I think we're both in agreement that those policies should not be referenced during the course of the trial, those changes. With respect to his other training, I guess I would seek clarification from counsel simply because there are training methods that have been approved. If we're talking policy versus training, I guess that's the question that I would have.
All right. You are, Mr. Iyer, you are essentially trying to get in the training that he had. I don't see any reason why that would not be relevant. I think that comes in, regardless of whether it's been embedded in policy or not. So I think we can probably deal with this when it comes up, drawing the lines on appropriate testimony. But if it's training Mr. Chauvin received before the death of Mr. Floyd, I think we have to recognize that that is relevant, and I would allow it, regardless of policy. All right. Does that answer the question, Mr. Iyer?
Yes, it does. Thank you, Your Honor.
All right. And the next, we are number 21?
Number 18, Your Honor.
18, I'm sorry.
18 and 21 are the remaining two. Your Honor, and perhaps my motion needs a little clarification. Number 18 seeks to prohibit witness police officers from testifying or speculating about what they would have done if they had been the person who arrested Mr. Floyd. We recognize that under the Graham versus Connor standard, that the question here is whether this was a reasonable use of force. And there are expert witnesses who are going to testify for the defense. There's expert witnesses who are going to testify for the state as to that ultimate question in terms of the reasonableness of the force. We also expect training officers from the Minneapolis Police Department to testify.
So we're going to be monitoring this procedural hearing. It's a motions hearing again this morning before jury selection is slated to start at 9 a.m. Let's get to Lou Raguse. Lou, what do you make of this, that they're not jumping into some of the things that we were mentioning, all the different court appeals that we heard about yesterday?
Well, one thing that people need to realize and learn, and it'll help as we continue to watch here, is how much the parties and the judge speak off the record when they're not on court, like on the live stream here in court. Like they talk in chambers, they do all sorts of communicating that we don't know about, that's private and off the record. So I am certain that they have discussed, like, okay, we don't have an answer back on this or this, so we'll just move forward with motions. And it's frustrating for us as observers when they come back and they don't really give that context, but that's probably what's happening behind the scenes. And so we haven't heard on the record anything concerning jury selection, so I would presume that is still scheduled to go on at 9 o'clock as Judge Cahill wants to. And I also presume that as soon as we hear something back from the appeals courts, that they will put it on the record on the live stream that we're all watching.
Yeah, and just in case you missed it, I mean, you heard Eric Nelson at the top saying, Frank and I have discussed this, about those motions that they were talking about at the beginning of this motions hearing. So like you mentioned, Lou, they are talking off record, and we just aren't privy to that information, unfortunately.
Yeah, and what you're listening to now are basically what they would be doing every day at 8 o'clock anyway. They have this first hour set aside for these motions. These motions are called motions in limine. It's kind of the ground rules that they're setting for the trial. You hear them talking about police training records, like what they can and cannot use as evidence when they talk about the police training records, and when they put people on the witness stand and question them about these records. So they do this now before the actual trial begins, so that they don't have to pause everything on the fly and say, hey, let's figure out what the ground rules are for this witness. Like they have a long list of these motions, and they go through them one at a time, compromise and come to an agreement on what they're allowed to do once the trial begins. As for those other bigger issues, we're going to have to wait and see. Anything could happen here. It's very fluid.
Yeah, and we'll be monitoring the situation, Lou. So if there's anything big that does happen, we'll be sure to check in with you later on. Lou, thanks for now. And Jennifer Austin picks up our team coverage outside the government center. Jennifer, what are you seeing so far?
Yeah, it's really quiet out here, Gia. Much different from yesterday. We've been out here all morning just kind of watching to see if people would show up again like yesterday. So far, that hasn't happened. We have Sky 11 up if you want to take a look. From my perspective, looking out on sort of the lawn in front of the government center, it appears most of the people on the ground appear to me to be other reporters rather than people out here protesting. As you can see, just really quiet. A reason for that might be this is going to be a long trial, up to 3 weeks just for jury selection. So organizers of the protest we saw yesterday told my colleague Heidi Wigdahl they plan on being here for key moments. So obviously yesterday was day one. They'll be back for opening statements and closing arguments. And again, of course, for the verdict. We want to show you video from yesterday. You can see the contrast. Hundreds of people were out here yesterday. About 20 organizations in total were organizing that protest. It remained really peaceful throughout the day, and really by the evening hours it had largely wrapped up. They marched through downtown, again, saying that the world is watching Minneapolis right now, watching this trial, and they wanted to represent their movement and be heard. Also yesterday, after court wrapped up, we heard from George Floyd's youngest sister. There are 2 family members allowed in the court during the trial, one a family member of Derek Chauvin, and then one for George Floyd. And yesterday, that family member was his youngest sister, Bridget, and here's what she had to say following court yesterday.
I sat in the courtroom today and looked at the officer who took my brother's life. I just really wanted that officer to know how much love Floyd had. Not only by me and his family, but you guys too, and the people around the country. He loved his family. He loved his daughter. Gianna meant the world to him. And we would never get that back. I want you guys to continue to pray for our family because we need it. We need it.
An emotional moment from her yesterday. Again, that was George Floyd's youngest sister we just heard from. Again, though, outside the government center this morning, very, very quiet. Gia?
All right, Jen, thanks for that. And of course, our Sky 11 over, and you can see there are no crowds like there were yesterday. Jennifer, thank you. And that is going to do it here for our special report. We will break it again if there are any big updates. And of course, we will have coverage for you all tonight on all of our newscasts. If you want to continue watching this live feed, we will be streaming jury election here on KARE11.com. Text the word trial to 763-797-7215 for a link to watch and our story with all the latest information. And remember to text that number. Do not call it. Back to regular programming.
We now return you to our regularly scheduled program.
And her own personal experiences and personal knowledge. And it's helpful to the trier of fact to understand Ms. Hansen's testimony and to understand what Ms. Hansen was saying at the scene.
I'm going to grant the defense motion to this extent. Ms. Hansen can describe what she saw. She can describe her training and experience. She can describe what she felt was indications that Mr. Floyd was in medical distress. She can indicate that she thought that at that time she thought medical intervention should have been started, because these are the things that she always does in the field, I assume, as a firefighter. She goes to the scene, she sees somebody is in medical distress and ultimately are in need of medical intervention. So she can testify to all that, and that explains her testimony. But to get to the point to make a medical testimony that she actually could have saved him is a medical testimony that she does not have the expertise, since she does not know all the other factors that are going into that. But she can say almost everything right up to that. The opinion that I could have saved him is not a proper opinion for her to testify to. But everything up to that, and why she thought medical intervention was required urgently because of what she saw, is certainly permissible.
Agreed, Your Honor.
So that's the court's ruling.
So I think those are the three defense witnesses that motions that we intended to deal with today. There is the state motion number 4 that we also wanted, and perhaps, and I apologize to counsel for the state for not bringing this to your attention, but with respect to number 5 of the defense motions, which was the criminal background checks of potential jurors, I may have inadvertently product, however, clearly establishes under Minnesota Rule of Criminal Procedure 901 that reports on prospective jurors are discoverable to the defense. So I would just note that.
Does the state have a response? I don't know who would like to respond to that. Anybody? Mr. Frank? Or?
No, Your Honor, we'll take a look at that and let you
All
know.
right, we'll return to that, but I'll be honest. When you stipulated to that yesterday, I was kind of puzzled because the rule specifically provides for it. So,
I think it was just because we were skipping around and with different motions and.
if you, I mean, the rule does not require that the state do these checks, but if they have and they have the information, I think the rule provides. But I'll allow the state to revisit.
All right, if I may.
Sure, you don't have to. I'm not ruling at this point now. So if you want, you can wait.
I think we may have been addressing this motion in the broader sense of other information or background information.
Right.
That which, if we have this, would clearly be work product. I'll double check the rule, and if he's right, we'll let the court know.
All right. All right, we'll reserve that until later when the state confirms what their position is. Is there anything else for this morning?
Number 4 of the state's motions, Your Honor.
All right. All right, who would like to argue that? Mr. Blackwell.
Good morning, Your Honor. So again, it's Jerry Blackwell for the state. Our motion number 4 is to exclude or limit any argument, evidence, or testimony regarding the MPD's decision in terminating Mr. Chauvin or the MPD's civil liability with respect to that lawsuit. And the reason and the context for this concern, we could see in the motion to dismiss for lack of probable cause, and this is the concern about it. As the court is well aware, the Minneapolis Police Department terminated Mr. Chauvin's employment on May 26th. And that may tell us quite a bit about what the Minneapolis community. The decision to terminate him after the fact doesn't really illuminate whether or not for the jurors the use of force at the time in question was objectively reasonable under all of the circumstances. And to interject that into the case in the framework of trying to introduce either politics or to throw in some reference to Chief Arredondo, who's African American, talking to African American faith leaders is unnecessary and carries with it, in my view, too much of a risk of prejudice and interjecting an issue of race in the case when it's completely not necessary or warranted by the relatively slight probative value of this in the first place. And the same can be said with respect, Your Honor, to the MPD's civil liability lawsuit. it just doesn't have kind of much bearing on what the jury has to decide, and then brings with it too much baggage.
What does the state intend on offering regarding his termination? Anything?
No, Your Honor.
Even the fact that he was terminated?
It's if it would be only the fact that he was terminated on the 26th, and that's all.
All right. Mr. Nelson, you want to speak to that?
Thank you, Your Honor. Mr. Black.
I'm sorry.
That's okay. It's a brave new world for us all.
It is.
Your Honor, it's certainly not the defense's intent to interject race into this particular question, or why that evidence would be relevant. I think the court needs a little bit of background factually to this question, because I believe that this information would be relevant and admissible under Rule 616 of the Minnesota Rules of Evidence, the rule of bias. Bias is admissible. It is provable by extrinsic evidence. Ultimately, Your Honor, the Minneapolis Police Department is a law enforcement agency. And we are aware, I think those of us who work, again, within the criminal justice system, that the police department's simple job, their primary job in investigating criminal activity, is to gather facts, to gather evidence, to gather information, to then form a legal conclusion with the assistance of a prosecutorial agency in order to charge someone with a crime. This becomes highly relevant to the issue of bias because, again, Chief Arredondo was interviewed by agents Ryerson and Peterson, I believe, the Minnesota Bureau of Criminal Apprehension, slightly or shortly after this incident. Chief Arredondo explained that what happened was he was made aware of the critical incident. He checked the milestone cameras, went about the normal critical incident policy, and then was made aware of the citizen-civilian Facebook video. He immediately recognized that this was going to have bad optics for the city of Minneapolis. He consulted with faith leaders. We don't have to involve, I believe actually there were probably additional faith leaders other than the African American community. He consulted with the mayor of the city of Minneapolis and made a decision within about 12 hours to terminate 4 Minneapolis police officers, 3 of whom he specifically states in that statement appeared to be acting consistently with training. So a decision to terminate someone based on an absence of evidence is probative of the chief's bias and concern about how the community would respond to this. So terminating Mr. Chauvin and the other 3 officers involved is reflective of potential bias. Further, Your Honor, with respect to the civil lawsuit, certainly I think the court is aware, Mr. Floyd's family has filed a civil lawsuit. The city has made a Rule 68, a substantial Rule 68 offer, and the city acted in an effort to immediately, within hours, to attempt to limit its liability and distance themselves from this incident, whether it be for politics or whether it be simply to potentially mitigate financial exposure to the city. That is the very nature of bias. And if Chief Arredondo is going to be testifying, not necessarily every aspect of it, but certainly the underlying fact that he made this decision absent a full investigation or even a partial investigation. He made this decision based upon how he feared the community generally would react to this. That goes to bias, Your Honor.
Do we anticipate, I'll throw this out to anyone, do we anticipate that Chief Arredondo is going to be a witness?
All I can say, Your Honor, is that the state has met with him on at least 2 occasions in trial prep, so I would expect that he would be testifying.
Mr. Blackwell.
Your Honor, we do expect that Chief Arredondo is going to be a witness. And let me just comment on a couple of the points that were made by Mr. Nelson, because he had made a couple of factual assertions that we take tremendous issue with. And the first is that Chief Arredondo made this decision in the absence of any evidence. It was based upon obviously plenty of evidence in the video footage that Chief Arredondo was then able to see. We consider that evidence. And Chief Arredondo saw it. There will be zero evidence in the case that Chief Arredondo went out to take a poll of faith leaders to decide what he was going to do. And if you look at the actual transcript, Chief Arredondo made his decision based on what he saw, based on his knowledge of what appropriate conduct was, and for him it just wasn't even close to the line when he made his decision. He informed the community of what he had decided. He wasn't asking them what he should do. And there's a big distinction. And it's,
well, doesn't this demonstrate the rabbit hole we all go down when we start talking about the termination and the civil lawsuit and everything else? Let's take it out of context of this case. If someone was charged with embezzling, not a public figure, their company fires them immediately, and the person is charged criminally, it certainly would not be admissible to say that they were fired by their company, because that's almost an offering an opinion, an implicit opinion, that they thought the person was guilty of a crime. So aside from the fact that all this was very public, the fact even of termination here seems to be inappropriate, because it essentially is implying an opinion by Chief Arredondo and the city of Minneapolis. The fact that they made a substantial offer and a Rule 68 offer, all of that seems to indicate we're just going to be chasing down, well, how extensive was it before he terminated? So if the parties are agreeable that it can be brought out that he was terminated on this date, that makes sense. But I think I'm not even sure why this should come into evidence at all. His employment status seems to be a different situation, and it could imply a conclusion that he was guilty of a crime, when it could have been a variety of reasons why he was terminated, or why the state is making an offer. I guess, so I throw that out to you. What are your thoughts?
Judge Cahill, it may have, I think, some probative value in simply framing his employment tenure with the police department. He started on X date, employment ended on X date. And whether it's ended by virtue of termination or however it's characterized, it just gives you the two hash marks of when he started, now when he finished.
Well, let me turn to Mr. Nelson. You can stay there. What about that? That's saying that Mr. Chauvin started on this date and ended his employment with Minneapolis on that date. Not terminated, ended his employment. Would the defense have a problem with that? Because I think that is relevant.
We don't have an objection to that, Your Honor.
Because that does not imply an opinion by the city of Minneapolis, although it may have been stated publicly, that would come into evidence in this case. And that's my concern, because in a normal case, we wouldn't even get close to talking about whether a person's still employed by their victim employer. So why, I guess, that's what I'm throwing out. I think I am going to rule in that manner, which is the state can bring out the dates of employment, and he is no longer employed by Minneapolis Police Department.
Thank you, Judge.
We avoid all this problem of why did Judge or Chief Arredondo terminate, all that kind of stuff. And it's very limited probative value, but I think you get it with what I have now stated the state will be allowed to do. Mm-hmm. Any questions about the limits on that?
Nope, understood, Your Honor.
All right, thank you. Do we have any other motions for this morning before we start jury selection? Or any updates from the Court of Appeals? As Mr. Frank checks his phone. Yeah, you can all check your phones if you'd like, just to see where we're at.
Nothing, Your Honor, sorry.
All right. Any other motions for this morning, though?
No, we got through those a lot faster than I think we anticipated, Your Honor.
Well, you all cut right to the chase and went right to the heart of the matter, which is appreciated by the court. All right, we're going to stand in recess then until our jurors are ready at 9 o'clock. Do we know how many we have?
Do you want me to check and see if number one's here?
We have to do the full advisory. We're going to start with the full group in the courtroom, where I'll essentially introduce them to the parties. So, and I turn to counsel. Do you wish to have me just introduce you, or do you wish to introduce yourselves to the jury?
Your Honor, on behalf of the state, I prefer to introduce myself.
All right, let's do that. You can all introduce yourself. I'll turn it to you specifically to introduce yourselves to the jury. All right, anything else?
Nothing, Your Honor.
All right, we're in recess until 9 a.m.